Today, first I want to say peace and greetings. Today, I'm getting ready to share with you a video entitled "The Child Support System is of the Devil. Woe unto you lawyers," right? Or something like that. So we're going to start off by reading Luke chapter 11, verse 52. Woe unto you lawyers, for ye have taken away the key of knowledge. Ye entered not in yourselves, and them that were entering in ye hindered. So this is the words of the Messiah himself. So for the people that claim to believe in Jesus Christ, you need to notice right here that he said, woe unto you lawyers. And woe means trouble, damnation, punishment, wrath. You understand? Because they have taken away the key of knowledge. Today they've done that with their legalese, right? Where they make it where you intentionally cannot understand the legalese or the legal words they use when you try to go into their courts, especially when you're dealing with child support, which is of the devil. The child support system today in 2022. What's today? I believe today is November 9th, right? Yeah, today is Wednesday, November 9th, 2022, as of the date of this video recording, and they are of the devil. All right, so let's get some proof that they are of the devil. I'm gonna zoom in here to make sure you can see it clear. We're at 28 U.S. Code 2007, imprisonment for debt. In other words, we're talking about debtor's prison. Now watch this here. A person, and we all should know what that word person is. A person in the legalese, right, which can mean not a human being, but it means a corporation, a trust, an estate, a partnership, so on and so forth, right? A limited liability corporation, all of that. A person shall not be imprisoned for debt. There it is. Shall not be imprisoned for debt on a writ of execution or other process issued from a court of the United States in any state wherein imprisonment for debt has been abolished. Well, it's supposed to be abolished in all of them. So we see how they slick got that in here. You're not supposed to have a debtor's prison, right? Nonetheless, let's keep going. All modifications, conditions, and restrictions upon such imprisonment provided by state law shall apply to any writ of execution or process issued from a court of the United States in accordance with the procedure applicable in such state. Let's keep going. Part B. Any person arrested or imprisoned in any state on a writ of execution or other process issued from any court of the United States in a civil action. Keep this in mind. Now we're talking about a civil action, right? Shall have the same jail privileges and be governed by the same regulations as persons confined in like cases on process issued from the courts of such state. So in other words, whether it's a criminal action or a civil action, if you get locked up, put in jail, right, you should have the same jail privileges and be governed by the same regulations as person confined in like cases, right? Meaning other cases where you can get locked up. They talking about criminal, even though they don't write it there. And I'm going to show you why they don't write it there, because they want to be able to lie, reinterpret, and change their codes and laws like the devils they are, just as it is written in the scripture we just read in Luke, right? Any proceedings for discharge shall be conducted before a United States magistrate judge for the judicial district wherein the defendant is held. All right, so just give me one moment here. All right, so now you see here we're looking at a court case. It says, in the Court of Appeals of Tennessee at Nashville, April 2nd, 2019 session. All right, And it says State of Tennessee ex rel Rachel Beth Haynes versus Alan Vincent Doherty, or Doherty, however you say it, right? Appeal from the Circuit Court for Rutherford County, number 57095. Diana Benson Burns, magistrate. All right. So we're going to do a little reading here, and we're going to uncover a good example of how these child support devils operate in this Court of Appeals in the state of Tennessee at Nashville. W. Neal McBrayer J., concurring in part and dissenting in part. When Alan Doherty fell behind in paying child support. So we see what the case is about. For his 3 children, the state of Tennessee, acting on behalf of the children's mother, filed a petition for civil contempt, right? So that's a civil action. Remember, we read about the jail. You're supposed to have the same privileges for a civil action as you do any other case. Mr. Doherty and the state agreed on the amount of the child support arrearage, $10,288.57. And Mr. Doherty further agreed that an automatic attachment could issue for his arrest if he failed to pay child support for a 30-day period. And that's bad that he agreed to that. And what they really mean is he was voluntold. He didn't agree. He agreed to that with tasers, nightsticks, handcuffs, and pistols being in his face, and cops standing 2 inches away from him. We already know that's what took place. But let's continue. The circuit court confirmed an agreed order reflecting both of these agreements. Mr. Doherty failed to pay as promised, and the court entered an order for Mr. Doherty's arrest with a cash bond of $13,413.45. The order further provided that upon payment, the bond funds would be forwarded to the state and applied to Mr. Doherty's child support arrearage. The court entered its order for Mr. Doherty's arrest relying on Tennessee Code annotated 36-5-101 F2, 2017. As the majority explains, the subsection provides for 2 types of bonds in child support enforcement proceedings. One type of bond secures the child support obligor's appearance in court. That's called an appearance bond. The other type of bond secures the child support obligation. That should be the performance bond, right? The parties agreed that the court was attempting to set the former type of bond an appearance bond. Well, there you go. They said it right in the document, okay? The statute does not specify that an appearance bond must be in cash, but it does set minimum and maximum limits on the amount of the bond. The bond must be not less than $250 or in excess of the amount of the child support arrears. You got the Tennessee Code for that, right? But let's go on down. See, this is 5 pages. I'm not going to read the entire 5 pages. Let's get on down. Here we go. So on page 2, this paragraph here is what I want you to pay close attention to, and we're going to expose how these people are devils, right? The child support system is of the devil. Woe unto you lawyers. I hope you receive all the wrath, punishment, and judgment that you so richly deserve. And every one of you who may be dealing with a child support issue, cleanse your conscience of any guilt associated with the fact that you may owe any arrears in child support. You don't owe them shit. I'm making it plain. You owe them nothing. All right? To hell with them. Mr. Doherty makes statutory arguments, here it goes, for why a bond payable only in cash is illegal, right? All of which I find unpersuasive. It shows you that the way they interpret law is their opinion, right? Their opinion, not facts. Because you got to persuade them. See? When you're dealing with God's law, you're dealing with facts. When you're dealing with the Most High's law, you're dealing with facts. But when you're dealing with devils, you're dealing with a damn opinion. All right? As apparently does the majority. The statute authorizing the setting of an appearance bond for child support enforcement proceedings does not specify any certain type of bond. In light of the lack of specificity, Mr. Daugherty argues that appearance bonds in child support enforcement proceedings should be treated like any bail bond. And he's correct, because we read where it says any civil action, you're supposed to have the same privileges as any other case, right? We read that in the codes. They're fake ass codes. He claims a statutory right to bail by a professional bail bondsman or corporate surety. All right? But as the state points out, the statute upon which Mr. Daugherty relies applies in criminal matters. So what they're saying is this child support case is not a criminal matter. I'm going to read it again. But, meaning they disagree with something. But, as the state points out, the statute upon which Mr. Daugherty relies applies in criminal matters. See Layton v. Henderson, right? Observing that bail statutes found in the criminal code do not have any application to habeas corpus cases which are civil in nature. And this is not a criminal matter. Do y'all see that? So let me scroll back up. Let's scroll back up. We dealing with child support, right? He has a child support or had a child support arrears for $10,288.57. Then they gave him a cash bond since he didn't pay the child support within 30 days like he said he would. $13,413.45. But when we go down here, they say this is not a criminal matter. That means you have committed no crime when you don't pay these bastards, these devils, right? Because that's who they are. And remember that. There's nothing wrong with you taking care of your offspring, your son or your daughter, but paying these damn corporate devils these Federal Reserve notes, which are not money, because there is no money, right? Unless you're dealing with gold and silver, you're not dealing with money. All right? So, Mr. Daugherty argues that the criminal bail statutes are applicable in this instance because this is a contempt proceeding. So they brought him to court for contempt for not paying the child support, right? And we know that when people go to court for child support contempt hearings, that they could be placed in jail unless they pay right then or they make some other type of continuance, argument, whatever. Under Tennessee Code Annotated 29-9-106A, 2012, upon an attachment to answer for a contempt, except in not performing a decree, the officer executing the process shall take bail from the defendant as in other cases. Mr. Daugherty reads other cases in the statute to include criminal cases. So according to him, the bail for his alleged contempt would be taken just as it would be in a criminal case. The fault in his argument is apparent from the statute's language. The statute accepts from its scope a contempt such as that allegedly committed by Mr. Daugherty. Look, allegedly committed. See, they're telling off on themselves. I thought either he committed it or he didn't, right? The failure to perform a child support decree, according to them, is not a criminal matter. So here's the question. Why the hell are you putting men in jail for it? That's because it is an unlawful debtor's prison, and you are of your father, the devil. You pieces of shit. Let's keep going. I find Mr. Daugherty's reliance on Tennessee's Rule of Criminal Procedure 42B3 unavailing for much the same reason. The rule applies to criminal contempts which are not at issue here. You see? So there you go. So there's more here. But the point is this. They admit to you that this man owing child support and being in court for contempt is not a criminal issue. But yet, they have arrested the man at least on one occasion, if not more. So you see that they are a bunch of lying demons. That's it, and that's all. However, when we come back here, 28 U.S. Code 2007, imprisonment for debt, we see a person shall not be imprisoned for debt on a writ of execution or any other process issued from a court of the United States, right? So here you go. So they have all kind of exceptions and tricks where they can lock you up. And we see that Mr. Daugherty did not receive this. Look, any person arrested or imprisoned in any state on a writ of execution or other process issued from any court of the United States in a civil action, which is what he was there for, shall have the same jail privileges and be governed by the same regulations as persons confined in like cases on process issued from the courts of such state. Well, there are other people who are incarcerated in the state of Tennessee for criminal cases, and they can have bonds, and their situation will be dealt with better due process. So in other words, fathers get treated worse than criminals. Just for being a father in this filthy ass piece of shit government, this corporate United States that's masquerading as a government, which exists in name only, yes, because it's bankrupt. Their lawyers are literally pieces of shit. And the family court / child support court is the bottom of the barrel. They are the worst in the whole legal industry. And so, they deserve death. They deserve wrath. They deserve whatever punishment the Most High will bring upon them. And they better hope that the men who are on child support don't decide to take up arms. Because anybody who kidnaps you and puts you in prison for a debt, that is called slavery. Right? That is slavery and involuntary servitude. I don't give a damn what they tell you. Yes, it is slavery and involuntary servitude, but it's hard to enslave a man who is not afraid to die. And that's all I'm going to say on that. See, they going to mess around and get a revolution started because they think that grown-ass men, right, who can arm themselves are going to be afraid of some fucking lawyers in suits and ties who sit behind a desk like a little bitch and treat men like shit. That day is over. I'm not saying it pretty. I'm not saying it courteous, friendly, nice. Fuck them. And that's how you should feel too. So, don't let them get into your conscience. Don't let them make you think that paying child support makes you a good man, because it does not. It makes you a slave. If you want to provide for your human offspring, your son or daughter, you provide for them in private like you made them directly. Right? Because your creator says so. Not because some wicked ass lawyer who's running a for-profit commercial court and a for-profit child support agency says so. Right? So with that, I hope you gain some insight and some freedom and some boldness and some strength. If anybody needs my help, you can go to childsupportgreed.com, or you can send an email to no more BS, and that BS stands for bullshit. In other words, no more bullshit, right? No more BS at childsupportgreed.com, and put in the subject line a private meeting, and we can get started on what it takes for you to handle your child support issue if you have any. Or if you know any man who's dealing with this wicked ass system who could use the help as well. Because I hope that you can avoid even being in the system. If they're trying to put you on this system, you really need to contact me before you get all the way in it. Because once you get in it, sometimes it's harder to get out, right? It takes a little longer to get out. But if you stop it before it starts, hey, there you go. So anyway, I hope this has been some help and encouragement to you. You don't owe these devils one damn penny. Tell them to go fuck themselves. And also, have a good day.